Good morning, counsel.
Good morning, Chief Justice. Good morning, members of the court. Thank you. My name is Sean Began. I'm here today on behalf of Scott Beres, who's the appellant in this case. What I'm asking the court today to do is to look at this case from an equity and fairness perspective. Mr. Beres was a licensed chiropractor in the Commonwealth of Massachusetts until approximately 2005, at which time his chiropractic license actually lapsed. Subsequent to that time, in 2006, there was a matter of litigation that was begun in Superior Court in Suffolk County involving Jason Corbett, who was a chiropractor who owned several chiropractic clinics within the Commonwealth. He was involved in a large piece of litigation involving insurance companies, specifically Commerce and One Beacon Insurance, in a dispute over payments to be made for treatment administered at his clinics. My client, who worked for Mr. Corbett, for approximately a period of 16 months, was made a party to that case in Superior Court. At the time that was done, my client was living in New York, unaware of that litigation. At the same time and contemporaneously with the filing of the complaint in Superior Court, counsel for Commerce and One Beacon Insurance filed complaints for disciplinary action with the Board of Professional Licensure. Again, filed by an attorney based on an expert review of medical records that were done and performed by a paid expert, obviously, for Commerce and One Beacon Insurance. Those complaints were not made by any individual or patient that had been treated by Mr. Beres. Mr. Beres was not made aware of that complaint until September of 2008, some 2.5 years after the complaint actually issued. In this time period and during that time period, the Division of Professional Licensure obviously had the time to prepare their case, get their own expert to review these files, prepare affidavits from that expert, prosecute, I believe, 3 or 4 other similar cases involving individual defendants involved in the Corbett case, who also were licensed chiropractors who worked for Mr. Corbett. Mr. Corbett himself was never actually tried. There was no hearing. He just simply surrendered his license before any administrative proceedings could take effect at the Board of Licensure. That matter of litigation in Suffolk Superior Court is still ongoing. Mr. Beres was dismissed with prejudice in the fall of 2008, just shortly before he was made and notified of this complaint pending with the Division of Professional Licensure. Mr. Beres retained me sometime in, I believe, March of 2009, after it became evident to him that it was not something that he was going to be able to dispose of on his own. And almost immediately upon me being retained, a motion for summary disposition was filed by the Board of Professional Licensure. Again, there was no discovery that had been done or that was allowed to be done on my client's behalf. The motion for summary disposition, in my view, had obviously been prepared. It seemed to me in other cases, similar, as I said, there were 4 or 5 almost identical cases. It was just a matter of switching patient initials in these motions and pleadings in order to make a new case against my client. The matter, an opposition was filed. The matter was summarily disposed of without even being heard on that motion by hearing officer Irene Carr. In the hearing officer's decision, is my opinion, Your Honor, and would have been argued on appeal, that she ignored completely the detailed affidavit of my client, who, again, is a chiropractor, and who brought specific instances where the prosecuting counsel's motion and petition was just wrong on its face in regards to the treatment records that were being evaluated and being considered. That was not discussed by the hearing officer in her decision. Following the issue of summary disposition and following a hearing on the matter of sanctions, at which there was not even a licensed chiropractor present, to hear my client's statements on the issues of sanctions. Sanctions did issue, and the sanctions were a 4-year suspension. That was the final order and decision of the Board of Registration. The prior chiropractors that had been prosecuted on essentially the same exact case and same exact fact patterns had all received probations.
Yeah, the issue though before us is not whether or not it was an appropriate decision below, but whether you are entitled to a review of that by
Yes.
this court. So if you prevail here, then you'll have a second chance to argue the equities and the law below, correct?
I appreciate that, Justice Gantz, and the reason I'm spending some time, and a majority of my time is going to be spent on the facts of this case, is because I understand that based on the Friedman case and based on the Hamill case, prior precedent in case law is not in my favor. When case law is not in my favor, I have to argue the facts. And I'm asking this court to exercise its general equity jurisdiction and see that justice is carried out in this case and that my client is allowed his full hearing where it's a matter of professional license is at stake, where a matter was summarily disposed of and where he received a punishment that was not in keeping with others similarly situated. And the court has already previously passed on that issue in matters of, specifically in the matter of bar discipline, the matter of Michael G. Moore, where there was disparate punishment for similar conduct. Your Honor, I think this is a case that is asking for this court, using whether through its powers bestowed upon it as being the highest constitutional court in the land, or through Chapter 214, Section 1, this general equity jurisdiction, to take jurisdiction over this case, where in fact, specifically in this case, where in fact this court is the court to hear such an appeal under Chapter 112, Section 64. And that is why I'm arguing to you on the facts of this case, as opposed.
Do you agree that precedent goes against you, both Hamill and Friedman?
I cannot argue that those cases are not factually similar to my case, that the precedent does go against me, Chief Justice. I think the facts of those cases can be distinguished to some extent, particularly Friedman, where Friedman was appealing. Friedman had already been, his license to practice medicine had already been revoked for a period of 5 years. He was attempting to get reinstatement of a license that had been revoked 5 years prior. He had already been before the single justice, so it seems as if he had gone through the procedure once and was unsuccessful, and now is bringing up a new issue for a reinstatement 5 years after the fact.
Well, in Friedman, the Superior Court dismissed the case, correct?
Yes.
So there was no possibility to transfer it since it was already dismissed.
And yes, it was. You're correct. The justice there did dismiss the case, and here Justice Hinkle has allowed me to petition, which kept the case alive so that I could petition the first. And
in Hamill, if I'm correct, the single justice in his discretion denied the request for transfer, but in this particular case, the single justice did not exercise discretion. She said she had no choice.
That's correct. My feeling is that she does have choice because she has the power to right or wrong if it's a substantial injustice, especially, as I said, where this is the court that has jurisdiction over these matters. Maybe more so than in another case where if I was coming before this court to ask that a statute, effectively I'm asking that the statute be told so that my petition can go forward. And I know that there are cases in which this court has taken it upon itself to issue rulings and grant itself the ability to hear matters and make decisions on matters where where strict interpretation of the statute may indicate that that right was not given. And one case which I found, Your Honors, on that point, which I thought it applicable. It's a case of the matter of Edward de Saulnier Jr. This was 360 Mass 757. In this case, this court took it upon itself to bestow itself the powers to hear disciplinary matters involving judges and to issue appropriate sanctions against judges where prior case law had indicated that only the Senate would have such powers through the Constitution of the Articles of Constitution of the State Commonwealth of Massachusetts. And some of the
I'm sorry, counsel, your time is up.
Oh, I'm sorry.
Thank you.
Thank you very much, Justices.
Good morning, Your Honors. Julie Goldman, Assistant Attorney General, appearing on behalf of the Board of Registration of Chiropractors. The plaintiff's case here concerns the 4-year suspension of his license to practice as a chiropractor. General Law, Chapter 112, Section 64, and this Court's decisions in Friedman versus Board of Registration of Medicine and later Hamill versus Board of Registration of Funeral Directors controls here. To establish subject matter jurisdiction in this court, the plaintiff had to timely file a complaint within 30 days of receipt of the board's decision. That did not happen in this case, and therefore, this court lacks subject matter jurisdiction.
He filed a complaint within 30 days, but not here.
Correct, Your Honor.
Right. And in Friedman, I take it the case had been dismissed in the Superior Court, and then he attempted to file here.
Correct, Your
which
Honor.
would have been beyond the 30 days.
Correct, Your Honor.
So we said essentially that the Superior Court filing didn't toll this 30-day period.
Correct, Your Honor.
But does that answer the question about whether we would have discretion, assuming timely filed in the Superior Court, to assume jurisdiction?
The facts, while slightly different in Friedman, are very similar to what transpired in Hamill, where the petition was filed in the Superior Court within 30 days, and the petition to transfer was filed in this court while the Superior Court matter was still pending. In Hamill, the court declined the petition to transfer, citing Friedman. Filing in the Supreme Judicial Court within 30 days for judicial review is a jurisdictional requirement and not susceptible to extension except in limited circumstances.
But why is there a jurisdictional issue if we simply have the case transferred from Superior Court to here? It's a transfer, it's not a dismissal, there's no need to toll. It simply is a transfer to correct the attorney's error. Why is that not within our jurisdiction?
I think if you proceeded in that manner, in this case, it would be directly opposite from this court's holding in Hamill versus Board of Registration of Funeral Directors.
Okay, well, let's then go to that then. Why should a professional suffer because his attorney errs with regard to the place of filing? Why is that a just result?
It's clearly been established through case law.
Okay, I'm asking about fairness and justice and the American way. Why is that a just result? Why is a professional to lose his license or her license because the attorney simply files the appeal in the wrong place?
I can't speak to that, Your Honor, other than referring you to the decisions of this court, which have stood for that proposition. Moreover, the notice of the decision sent by the Board of Registration in this case to the plaintiff specifically specified that any judicial review should be sought in this court within 30 days, and that was not done here.
Okay, but I guess the problem, of course, is that if money was at issue, then the litigant could sue the attorney for malpractice and get money, but suing the attorney is not going to get the person's license back. So you're saying you're just out of luck? If you choose the wrong attorney, you're out of luck?
Pursuant to the line of cases that I have cited in my brief, yes, Your Honor, that is the result. There are no further questions.
Thank you, counsel.
Thank you.